Hello everyone, and welcome to the latest of Fieldfisher's privacy webinar series. Today is our end of year extravaganza, and we have brought together partners from our London, Spanish and German offices. My name is Hazel Grant, and I am the head of privacy based out of our London office. Thank you for joining us. Today we're going to look at some of the key privacy developments in 2022, and each of our speakers will consider a trend for 2023. We will look at ad tech and cookies and enforcement, of course, and transfers to the US, upcoming legislation and EDPB guidance. So, can we have the next slide and let's meet our speakers. So as I'm speaking, I will start. As you've heard, my name is Hazel, and as you already know, when I don't have my nose inside some data protection guidance or cases, I can be found surrounded by various animals: cats, dogs, quails, chickens, horses, sheep. No, I don't live on a farm, but sometimes it feels a little bit like that. So let's meet our other speakers. Renzo, you have a couple of sentences and I need something quirky.
Okay, thanks, Hazel. So I'm, like Hazel, I'm a partner in the privacy team in London, supporting clients across all different sectors. I've been practicing data protection law long enough to have advised under 3 separate UK regimes, going back to the 84 Act, then the 98 Act from the directive, of course, and then the current GDPR 2018 Act. And despite what I'll be talking about later today, I really do hope I won't have to advise on a 4th.
Excellent. Thank you very much, Renzo. Okay, Leonie, let's hear from you.
Thanks, Hazel. So my name is Leonie Power. I am a partner in the tech and data team, also at Fieldfisher, specializing in everything and anything privacy and data protection related. I don't have a particularly quirky fact other than my surroundings are a lot more urban, it sounds like, than Hazel's are.
Okay, thank you very much. Okay, let's meet Olivia.
Thanks, Hazel. I'm Olivia Wilson-Morgan. I am a hybrid partner sitting across the tech and data side of the team here at Fieldfisher. Been here for 11 years now. And whilst I'm going to steal Hazel's animal theme, I have a Labradoodle called Ernie, who's very antisocial and very grumpy when I had to move him out of the room for this webinar.
Thank you, Olivia. Okay, Thorsten, also known as Mastermind, given the spotlight on you right now, let's have your introduction, please.
Thanks very much for passing on, and also for the mastermind. When I'm not on the panel with the experts, I'm also a privacy partner. I'm currently traveling. I hope this is working out on the mastermind panel. And I only have 2 regimes to come up with, opposed to Renzo's 3 of legislation. I'm based out of Germany, so maybe that's a differentiator on the panel here. And also, I'm very often the outside DPO for clients. Maybe that's an interesting perspective for some of you.
Thank you very much. And last but certainly not least, let's have Carlos.
Thank you very much, Hazel. So good afternoon, everyone. My name is Carlos Perez, and I am a partner at the Tech and Data Practice at Fieldfisher in Barcelona, Spain. Living in the middle by the sea, but also very close to the mountains, where I really long to go when the ski season gets started, which is really right now. I'm still wondering because the first piece of law that I read when I started 30 years ago in this practice was the first data protection law that was passed in Spain. I'm thinking to myself, what a boring piece of legislation. Who's going to make a living out of this? And here we are.
Thank you very much. Here we are indeed. So for those of you who don't already know us, Fieldfisher is an international law firm with offices across Europe, as you have just seen, also in Silicon Valley and in China, and our privacy team works across all of those offices. We are a collaborative team providing strategic and actionable privacy solutions. I know you're going to hear about that in this webinar. So turning to housekeeping, please do ask us questions through the question function on your screen. We've left a little bit of time for that, and we should be able to get through a few questions. We will try to take them at a convenient time during the webinar, so do keep them coming in. We will also try to leave a little bit of time at the end. If we don't manage to answer all of your questions. We will respond to them in writing, and we aim to finish at 5 p.m. UK today. Now, in keeping with the fact that the world has gone football mad, I shall be using the following cards, both red and yellow, to keep my speakers to time today. So, Leonie, since you're going to be first up, yellow is a 2-minute warning, red is a 30-second warning, just so you know.
Just don't
lastly,
send me off.
Okay, I'll try not to send you off. So later this week, we will send you a copy of the slides together with a recording, so don't feel that you have to take notes on everything. And a couple of final points before we hit the first topic. Please do subscribe to our blog and keep an eye out for our other webinars, and also our Data Protection Fit series, which is on our YouTube channel. So let's move on to the first speaker, please. And can I hand over? Oh, sorry, I've just completely ignored the agenda. Never mind. You know what's going to happen. Here's Leonie. She's going to take you through ad tech and cookie compliance. Over to you, Leonie.
Thanks very much, Hazel. Okay, well, as Hazel said, my piece is to look at some of the key ad tech trends over the last year. And a particularly noteworthy development came in February 2022, when on the 2nd of February, the Belgian DPA issued a ruling against, or in relation to the IAB Europe's transparency and consent framework. And in particular, it found that that framework does not fully satisfy e-privacy and GDPR requirements in its current form. Now, by way of reminder, that framework is aimed at supporting the various players in the ad tech industry, be they publishers or be they other ad tech vendors, to comply with their GDPR and e-privacy requirements. So be that in the form of obtaining the necessary cookie consents or providing the necessary transparency information to users about how their personal data is used, or identifying another legal basis on which to process personal data, such as legitimate interests. As part of its ruling, the Belgian DPA indicated that the IAB Europe should produce an action plan by the 2nd of April 2022. That was produced on the 1st of April, the idea being that it was to be agreed between the Belgian DPA and IAB Europe, and then there would be a 6-month implementation period with regard to the various remedial actions. However, that remedial plan and the agreement of that plan has been suspended, and it was suspended when the IAB Europe announced that it was filing an appeal against the Belgian DPA's decision on the 4th of March. It was expected that the decision of the Belgian Markets Court that would be given in November of this year. However, this year, in a twist in the tail, the Belgian Markets Court referred certain questions to the Court of Justice of the EU. The key aspects of the referred questions are whether the transparency and consent string, with or without an IP address, amounts to personal data in itself, and also whether IAB Europe and TCF members are joint controllers for the purposes of Article 26 of the GDPR. Now, it's not expected that we will have answers from the CJEU on these questions anytime soon. It's anticipated it will take a bit of time. And so it's unlikely that we're going to have clarity or certainty on whether the TCF is to be considered a valid mechanism for ad tech consent and transparency for some time. The expectation is that it will probably be late 2023 or even the start of 2024 before we have a bit more certainty on this particular point. In the meantime, activists are calling for the Belgian DPA to enforce its original order in relation to the relevant action plan. So it's a case of watch this space on that particular issue. Next slide, please. So another trend in the ad tech space in 2022 was a decision of the Italian Garante in relation to TikTok. So the Garante issued an urgent decision on the 7th of July 2022, indicating by way of warning that personal data stored in user devices may not be used to profile those users and send targeted ads without explicit consent. Now, what had triggered this urgent warning was that TikTok had previously modified its privacy policy to say that as from a particular date in July, the processing of personal data would be based no longer on consent, but rather on legitimate interests. And that included in relation to personal data stored on user devices. And that's what triggered the decision. The Italian DPA essentially concluded that this processing of personal data contained on user devices on the basis of legitimate interest was in conflict with the e-privacy directive. Now, the Garante further confirmed that it had informed the European Data Protection Board and also the Irish Data Protection Commission of its decision, and it advised those parties that they should consider taking urgent action within the framework of the cooperation procedures under the GDPR. Now, what's particularly significant about this decision is that it is probably the first time that a regulator has acknowledged its view that personal data that's collected via cookies or contained in cookies that is used for other purposes needs a legal basis for processing other than legitimate interest. In other words, it needs consent. The ICO had previously hinted at that in its ad tech update, but it had left the door open to the possibility of legitimate interest, where we have a very definitive statement from the Italian Garante on this particular point. The Garante also indicated that were TikTok to proceed with their plans, they reserve the right to take further action, including imposing sanctions. Next slide, please. And a third trend or a third development is more the continuation of a trend, which is the focus by regulators and by activists on cookie compliance. And in August 2022, None of Your Business filed a further 226 complaints in relation to cookie banners. None of Your Business, some of you may be aware, is the organization headed up by Max Schrems. And they identified that across these complaints, a number of so-called dark patterns emerged. The first that was identified was the lack of a reject button on the first layer of the cookie banner, which basically nudged individuals to accept cookies rather than reject them, because it meant that otherwise they would have had to go to a more options button or the second layer of the cookie consent mechanism in order to change their settings. Another so-called dark pattern that was identified by NOYB is that of pre-ticked boxes in the second layer of the consent mechanism. So indicating or again nudging individuals to a default position whereby they accepted cookies rather than changing their settings. And another pattern was in relation to various nudge techniques. So designs built into the cookie banners that made the accept button more visible, be that by way of larger fonts or by color, again, nudging individuals to accept cookies rather than changing their cookie settings. So these patterns were the ones that were identified by NOYB. We don't have any regulatory response to those particular complaints or to the earlier complaints as yet. We have various guidances from various regulators that pick up on some of these points. So again, it's a case of watch this space to understand how the regulators will respond to these latest complaints. It's worth saying that in the meantime, of course, we've had the EU Digital Services Act come into force, and that's due to become fully applicable at the start of 2024, and that explicitly bans dark patterns. And so finally, just to say a word in relation to trends for the coming year, 2023, I think a trend is likely to be that we're likely to continue to see a focus by regulators on activists on the area of cookie compliance, and in particular in the ad tech space. I think it's within the focus of regulators currently to look at tracking across websites, invasive profiling and other tracking practices, and I think that will continue to be a focus of regulatory scrutiny over the next 12 months. And on that note, I will hand over to Carlos.
Thank you, Leonie.
Thank you,
Okay,
Leonie.
Carlos.
So, thank you. So we're going to be talking about what are the recent developments on the data transfer to the United States. So if we go to the next slide, please. what we'll see very basically is why the decision of the European Court of Justice on the Schrems II decision made that both legislation, the European and the United States legislation, were totally incompatible in terms of data processing. There were two main reasons. One is that the US legislation is providing, or was providing until today, a very broad access to information coming from abroad by US government intelligence, and that such access was not subject to the principles of necessity and proportionality, which are the basic principles of the European legislation on data privacy. The second the second motive why for this incompatibility is because the US legal system doesn't have a proper redress system that allows citizens and European companies just to really file complaints to make the European principles respect, and a lack also in the US system of an independent supervising authority that could control the respect of these European principles on data protection. So if we go to the next slide, let's see how the recent developments have been moved so that these incompatibility between these two legislations might be solved. This is coming from the recent developments, mainly in the United States legislation, which is defined as the US Data Privacy Framework, which is which consists of three elements, which we will develop further in this presentation. One is the recent executive order that has been published by the Biden administration. Second is the complementation of this order by the Department of Justice regulation and the commercial aspects. On top of that, and after this new American legislation has been passed, a new decision from the European Data Protection Board on the adequacy of the United States legislation will have to be published, and this will just seem to have solved the problem in a very important way. So if we move to the next slide, so let's see what are the three elements of the United States legislation which might be solving the problem. First one are the commercial aspects, which mean that what are the data privacy principles to which the companies and organizations in the United States should be adhering to in order just to respect these European principles. This is not being changed so much because it was not impacted by the Schrems II decision, but it will need to be updated because these commercial regulations still make reference to the directive prior to the GDPR, so it will have to be updated according to the GDPR. A new guidance from the Department of Commerce from the United States government will be coming so that companies in the United States might be in full respecting these commercial aspects. But the main new things are coming now. So if we move to the next slide, first main novelty in the United States legislation is the approval last month of November of the Executive Order 14086, which is immediately effective, and it is addressing one of the main important motives of incompatibility of the two legislation. According to this executive order, all intelligence bodies in the US government must respect the principles of necessity and proportionality when accessing to data in tracing the signals, which include personal data which are coming from abroad, from outside the United States. What this executive order is included is a definition of these principles, how they must be respected, a practical guidance on how these principles must be construed and how they must be applied, and includes also the definition of what are 12 legitimate objectives or accessing to this data, for instance, protection of US officials in protection for the risk of their lives, or for instance, it also includes 4 types of forbidden objectives of accessing of data. For instance, surfacing or burdening, criticism, dissent of the free expression of ideas or political opinions. So if access are done in this way, this will be considered as forbidden. So intelligence bodies in the United States government will not be allowed to access in these circumstances. In addition, the executive order, what it's providing is a regular assessment of these accesses to information by the Civil Liberties Protection Officer, which is an independent authority which is included or depending on the Director of the National Intelligence, but the executive order is defining the ways that ensure his independence. And also, the executive order includes an explicit submission to all decisions that might be issued by the Data Protection Review Court, which we will explain later on, to all US intelligence agencies. So any decisions that are issued by this court, which are forbidden or restricting access to data, must be in full respected by any US intelligence agency. If we move forward, This executive order is completed by developments which have been approved by the Department of Justice. Can we go to the next slide, please? So there are included a number of new things, which is, if you remember at the beginning of the presentation, I was explaining that one of the main problems of incompatibility was the lack of existence of a redress mechanism in the United States legislation. So these Department of Justice regulations, which have been recently approved, include a two-step redress mechanism. One is the control by the Civil Liberties Protection Officer, which he will be entitled to receive complaints by any citizens or any companies from qualifying states, which means from countries which are asking to respect these data protection principles. And this protection officer will conduct investigation. All intelligence bodies are tied to this decision, and also will issue a classified report with the decision as a result of the complaint that might be lodged before such protection officer. The decision of this protection officer will be able to be challenged to the Data Protection Review Court. And this Data Protection Review Court will be formed by 3 judges, which will be appointed by the Attorney General from a roster of prestigious judges in the United States, but that will be selected after the input of the Secretary of Commerce, the Director of the National Intelligence, and the Privacy and Civil Liberties Oversight Board. So their decision is controlled in order to ensure their independence in the decision. If we go to the next slide, finally, these Department of Justice regulations also include some measures to ensure transparency. Both the Department of Commerce and the Privacy and Civil Liberties Oversight Board will do a review. They will do reviews on the activities that might be submitted to the access of intelligence bodies in the United States government, and they will be able to decide which of these accesses can be unclassified and which of them will not be unclassified, so that there's most transparency about all the accesses done in the past. And just to make sure the independence of the role, it has to be said that the executive order and this Department of Justice regulations make clear that the Privacy and Civil Liberties Oversight Board is performing not under the mandate of the administration, but under the mandate of the Congress. So that ensures the ability of control really independently the decisions of access to information. Finally, the Department of Justice regulations are reinforcement, also the Data Protection Co-Review and their independence, because they are forbidding the Attorney General to interfere in the decisions and to push in the dismissal of the judges that are part of the Data Protection Co-Review. Next slides, please. So, finally, what we are expecting is the European Union now to do its job. So what it is expected is that there is a new adequacy decision that is issued by the European Data Protection Board. It was announced that it should have been released yesterday, but finally it hasn't been. And even though what will be happening is that the European Data Protection Board should draft a decision just proposing or confirming if these news in the United States legislation are enough to make them compliant with the GDPR. But all this process will take some months, but it looks like that it will finish with a decision confirming that the United States legislation is accurate and is compliant with the GDPR. Next slide, please. So is this the end of the road? So is this the final solution to the real problem that we've been facing since the Schrems II decision, which really made it very difficult just to rule, for instance, the contracting of cloud providers or technological providers in the United States, because there was this full incompatibility? Well, it seems to be because the United States legislation appears to have embraced the European data protection principles, but we still have to wait. We have to wait to the adequacy decision, and also we'll have to wait to the role of control of the European Court of Justice. We have to bear in mind that there are two authorities of control in the European Union, France and Germany, that have been banning some providers because of these transfers of data to the United States. So the European Court of Justice will also give his decision and his opinion about if these measures and these news in the United States legislation are enough to make them compliant. So, and also the European Court of Justice will play a role in supervise if these redress mechanisms and all these measures introduced by the new data protection framework in the United States are really a practical solution and really protecting the rights of the citizens and the companies in the European Union. Finally, last but not least, we have to bear in mind that this new data protection framework is solving the situation with the United States. But let's not forget that most of the provider of services in the United States are not only performing their services from their own country, but they're also relying on subcontractors which are located in other third countries whose legislation is not equivalent to the European data protection legislation. So be careful. Whenever we have to analyze if engaging with a provider of services or with a third party in the United States is enough, we don't have to stop in just on the fact if they're providing the services just from the United States. We have to bear in mind if there are subcontractors or onward transfers to third countries, whose situation is not solved, obviously, by this new legislation in the United States. So this is the end of the presentation. This is how is the situation now currently with the international transfers of data to the United States. And before moving to Thorsten, just my proposal on the new trend for the new year. My view is that there will be really a race of relationship between the data protection legislation and the free competition legislation. There's a lot of situations in mergers and agreements between corporations that might be having an impact both from the data protection and data privacy legislation and the free competition legislation, and that will be growing from my point of view in the coming future. So with this, over to you, Thorsten, and thank you very much.
Thank you, Carlos, and what a cue. Can we please move to the next slide already? I will try to turn this around and use what Carlos just said, because my tip for the trends to come the next year is more disputes, possibly more real litigation, which we're doing a lot in the courts, going against regulators and individuals. And also the competition angle is really important. And I'm going to use this slide and the next one just to maybe not prove it, provide some evidence on why I think so. So you can think of this slide we're seeing here as individuals coming after you for privacy enforcement, not only in Germany. Obviously, I'm a German lawyer, so I advise on German and EU law mostly, but I'll tell you what is going on in the other countries as well, where there's a perspective for those. The next slide, please don't bring it up yet, that's going to show you more institutional perspectives on how enforcement works. Could we move back to the previous slide, please? My first one. Thank you. The first one is a money-making scheme. I have to be clear and blunt on this one. There's thousands of letters out there, really, possibly tens of thousands, by a couple of smaller law firms or individual practitioners who take an individual, a data subject, and use their rights, their GDPR rights. They could also use their e-privacy rights or other individual rights, and use them to send you a so-called cease and desist undertaking. This is a mechanism under German law, which is actually rooted in competition law as well. And we'll come back to that on the next slide too in a moment. So the idea is they want you, in this particular instance, to either turn off Google fonts and the incriminating US transfer, as they like to present it, because where you've not collected consent, obviously, they're making the point that you cannot transfer for other than strictly necessary purposes under e-privacy or maybe ancillary and onward GDPR purposes. So they send you this nice letter with a couple of pages, maybe worth of evidence they provide by an individual whose rights were allegedly infringed by accessing your corporate website, nothing more serious than that, just your brand on a website. And then they want a couple of euros, if it plays out in mainland Europe, in legal fees and maybe for damages. So we're speaking on the order of 3-digit sums, which might prompt you if you receive a letter like this. And I can only guess a couple of people in the audience have actually received this or at least seen it in the past. Then you might think, let's just pay 200 euros or maybe 200 quid elsewhere in the world. But don't be too rash, I would say, because there are good arguments to fight back, at least for a while, maybe even take counteraction. And perhaps the prevalent strategy on responding to this is perhaps to ignore this. Now, generally, I would advise against ignoring a cease and desist undertaking. If you receive it by letter from a law firm, you have to do something about it. But in this case, I can tell you there have been complaints filed with the SRA equivalent, so the self-regulatory body of lawyers in Germany, against these law firms, and apparently, reportedly, also even criminal charges for fraud. Those are serious allegations, and they will be looked into due course over the next couple of months. But so far, there are no reports of actually enforcing these cease and desist undertakings and legal fees in court. Why? Because that will probably not pay well. It's not not making money anymore. If you have to look into individual cases, then your whole scheme breaks together, and you can't live off the thousands of companies paying 200 euros each. And something similar we see for individuals. That's the second point here. That come after you in employment disputes, for instance, or something that's apparently happening in Austria right now is people going after the gambling payments for online casinos. And I've seen this happen actually as a DPO for a client in Germany, where they use their GDPR subject access right to come by transactional records to have evidence of the payments they made to the online casino. Can we move to the next slide, please? Thank you. So these are more institutional enforcers, consumer watchdogs, the regulators, and then governmental bodies in a way, although that's perhaps the other way around, defending against GDPR allegations. So consumer watchdogs in Germany for decades have been going after your terms of service, actually, because privacy notices by judgments we have in Germany can qualify as standard business terms, which means you can apply consumer protection rules to them if they're used by a company towards consumers. And perhaps the particularity here is, in these court cases we've seen, that the judge only looks at the letter in your privacy notice, not what you're actually doing as a practice in the background. They're coming after what you're writing into your privacy notice, which is why I have to sometimes tell my colleagues in the other countries and offices that it's important to get your privacy notice right in Germany if you have a very popular brand out there and deal with consumers. Because it may well happen that a court may look at it irrespective of how good your processes are in the background. So the supervisory authorities, my second point on this slide, are becoming more inquisitive and more procedural. They're issuing more fines. We know that this is happening more, let's say, in Southern Europe, where they seem to be trigger happy on lower level fines. Not that much in Germany, but they're gearing up in Germany as well, and you should expect more fines there too. And something that we've seen for quite a while is if they do send you a letter because of an individual complaint, typically, then they might also send you like a question catalog on CCTV. Let's see, I've seen this, a couple of questions, sometimes a dozen questions, just firing them your way. Whatever you've done, even if they don't know yet, they just have the standard questions, plus asking for your ROPA. So you better have that in your drawer or are able to produce it from a 70% approach to an almost spotless approach in very short time, so you can answer to the requests in due time. And the last one here is very relevant, especially for US cloud vendors, where we've defended some of them in administrative court proceedings, where a governmental body said in their RFP and the tender document that they didn't want US cloud vendors to pitch for larger projects or even continuous services, because I thought was transparent. The governmental body didn't want to do TIAs, and didn't have capacity and expertise, perhaps, to conduct full privacy compliance reviews on the necessary transfer for using the US cloud vendor. So I think this shows where we're going in terms of disputes of contentious matters. And yeah, this happens to you, please feel free to drop me a line by email or on LinkedIn or call me. We've defended quite a few of these cases. Happy to help you there if you like. And so, would you like to take on the next part, please?
Thank you, but I'm really jealous of your really cool background, Torsten, and here I am in a boring white office of your lovely black. Thank you, everyone. So I've got two developments in the UK to tell you about briefly, both of which could, each of which could in fact be at least an hour-long webinar. Data protection legislation being changed in the UK potentially, and then I'll come on to ICO guidance on transfers up to the news from about a month ago. So what's been happening in the UK Parliament? Well, I mean, obviously, those of you in the UK will know this, and those of you elsewhere in the world will also know that we're now on our third UK government of the year, probably the last one for no more changes until 2024. And so it's a little bit uncertain exactly what's going to be happening with the data protection and digital information bill that was introduced into Parliament by the government before last. That's the Boris Johnson one. It looked like there was going to be a wholesale replacement of that with a British data protection law, but it looks like the current government is going to proceed down the train that was the track that was started by the Johnson government, which is to tinker with UK GDPR rather than a wholesale change. So the little tinkerings are, I'll give you a flavour of them. They're not particularly dramatic. A reform of the accountability principle, for example. So you no longer need to have a data protection officer, at least some organisations won't, but will need to have a senior responsible individual with tasks not too dissimilar from a DPO. Legitimate interest, the legal basis in Article 6(1)(f). No longer, in some situations, will you have to undertake a balancing test. The interest will be deemed to be fulfilled in some situations. A particular one of note is fraud prevention. Exemptions for subject access rights are being widened. No longer can you refuse only on manifestly unfounded, but also if they're vexatious or excessive. And the last one I want to highlight is a change to the cookie exemption rules, to an expansion of those rules, so that puts it beyond doubt that analytics cookies are exempt and anti-fraud cookies are exempt. And of course, that really reflects what's going to be happening, or potentially happening in the EU anyway, with the revised the revision to the Electronic Privacy Directive being replaced by regulation, but that seems to be installed mode at the moment. The other big legislative development is relevant to not just data protection law, but loads of laws, which is part of the Brexiteer agenda of removing from the UK statute book any law that was preserved at the end of the Brexit transition period as retained law, which became domestic law. All those laws, and the latest count is well into the 4,000 laws, covering everything from air safety to farming to data protection, GDPR, will fall off a cliff and no longer be UK law at the end of 2023, says this bill, unless a government minister says otherwise. And this is widely criticised as being rather foolhardy and impossible to achieve. That 2023 date has already been stated will be extended to 2025 and 2026, and we might well have a new government by then. There will certainly be an election. So watch this space. I don't think we're going to lose GDPR as a result of that bill. So moving on, I'll try to move a slide and I've failed. Thank you. The ICO has issued some important papers just last month in relation to transfers, an update to its guidance. But what I'm going to talk about is its approach to undertaking transfer risk assessments required by the Schrems judgment, which is still, of course, law in the UK and a tool that accompanies that guidance. So the aim here is to give an alternative approach to that set out in the rather difficult to comply with, if I could be polite, European Data Protection Board recommendations from a while ago now, 2020, end of 2020, wasn't it? Was ensuring the assessment is reasonable and proportionate. So that's music to a lot of people's ears if you're transferring from the UK, of course. The next slide, please. So to give you a flavour of the way the ICO is approaching this is they set out 6 different questions or steps, and just 3 of them here. It asks you to assess the personal data risk level, look at the data and determine whether it's low risk, medium risk or high risk. Depending on this, then different actions will be needed. And that risk assessment on data is a nice point of departure, of course, from the very prescriptive European Union approach. It informs question 3, what is a reasonable and proportionate investigation to do in relation to a foreign destination country? Well, that depends not only on the type of data now, but also the size of the organization. And that's a curious one. So if you're a global giant, you are expected to undertake something like the EDPB recommendations. But explicitly, if you're not a global giant, in fact, the ICO uses the tiers, which are those that determine the data protection fee that you pay as a registering controller in the UK. If you're an SME, for example, they might just ask you to look at some resources which they themselves publish, and that would be reasonable and proportionate. And the last question I'll just briefly touch upon is that which the risk assessment, depending on the level of investigation as mandated of you, that you need to undertake, isn't an absolute risk assessment either. It is there a significant increase in the risk because you've sent the data abroad? So if the data was actually at risk in the UK, does it actually significantly change if you move it out of the UK and elsewhere? So that gives you, I hope, a little bit of a flavour. Changing topic and trends for what's going to happen in 2023. So my prediction on trends is that more people are going to get excited about machine learning and AI, and the thorny problem that we've seen quite a few clients begin to address, and more will in future address, is the enterprise solution providers' use of their customers' data for the purpose of improving algorithms and their products. I think a lot of service providers are going to continue to look at that, worry about how to comply, and I think a lot of their customers are going to begin to ask more questions in relation to that. So I will now hand over to Olivia.
Thanks very much, Renzo. So there has been plenty of legislative activity over the last 12 months that I could have picked from, but I'm choosing to focus on the revised NIS directive, so NIS 2. So if we move on to the first slide, please. As a recap, in 2016, the Directive on Security of Network and Information Systems, the NIS Directive, was the first EU-wide legislation on cybersecurity to enter into force. NIS 2 repeals the NIS Directive and seeks to replace and build on it. NIS 2 will apply to certain, what it calls essential and important entities operating in a defined list of sectors, including critical infrastructure entities. The overarching objective of the NIS 2 directive is to further improve the resilience and incident response capacities of both the public and private sectors, as well as across the EU as a whole. In terms of scope, as a response to the generally increased exposure to cyber threats within Europe, NIS 2 has a broader scope than its predecessor. The original 19 sectors in scope increases to 35 sectors. By way of a reminder, the original scope of the NIS directive includes operators of essential services, OESs, for example, entities maintaining critical energy, health or transport infrastructure, and digital services providers, DSPs, for example, certain providers of online marketplaces, online search engines, and cloud computing services. NIS 2, on the other hand, refers to essential entities, as outlined in its Annex 1, and important entities, as outlined in Annex 2, with the distinction between the two being based on each sector's criticality to the economy and society. There's no longer a distinction between OESs and DSPs. NIS2 will cover, for example, providers of public electronic communications networks or services, social networking services platforms, and data center services. Manufacturers of certain critical products like pharmaceuticals, medical devices, or chemicals are also covered. NIS2 also introduced a size cap so that all medium and large entities that operate in the sectors covered by the new text will have to comply with the requirements. If we move on to the next slide, please. In terms of timeline, NIS2 was approved by the Council of the EU on the 28th of November and formally adopted. Member states now have 21 months to incorporate the provisions. Next slide, please. So in terms of key developments and practical implications, what does NIS2 do? A key aspect of NIS2 is that it imposes direct obligations on management bodies, so those that discharge managerial functions. The obligations relate to implementation and supervision of their organisation's compliance with the legislation. Failure to comply could lead to fines and a temporary ban from discharging managerial functions, including at C-suite level. NIS2 imposes a cybersecurity risk management approach and includes a minimum list of basic security elements that must be applied. It also requires companies to address cybersecurity risks in supply chains and supplier relationships, and that would include taking into account the overall quality of products and cybersecurity practices of their suppliers. That means, of course, that organizations outside the direct scope of NIS2 may ultimately become impacted by NIS2, for example, if it provides certain IT-related services to customers who are within scope of NIS2. If we move on to the next slide, please. In terms of enforcement, NIS2 establishes a minimum list of administrative sanctions that apply when an entity breaches its cybersecurity risk management or reporting obligations. These sanctions include imposing binding instructions, a temporary suspension or prohibition to conduct certain activities or to exercise certain managerial functions, or an order to implement the recommendations of, for example, a security audit. NIS2 has pretty hefty fines as well. They are set at the higher of 10 million euro or 2% of total worldwide turnover. And these fines kick in cases of non-compliance with risk management measures or the reporting obligations. In addition, member states are granted discretion to set out effective, proportionate and dissuasive penalties for breaches of NIS2, and these will be in addition to the administrative fines that I've just mentioned. So next slide, please. So in terms of NIS2 takeaways and what you can be doing now, assess the extent to which you're caught by NIS2, and this assessment should be carried out on a per service basis. If caught, you should make sure to extend your management and response plans to include supply chain due diligence and the updated incident report requirements. You will also need to update technical and organizational measures to reflect NIS2 requirements. Importantly, providers of information and network security products and services, which may not themselves be covered by NIS2, should also be prepared for due diligence from in-scope NIS2 organizations. If this is you, you should ensure that robust documented processes are in place to manage security risks associated with your product and service offerings in anticipation of any such due diligence. So, in terms of trends looking forward for the next 12 months, I think there's going to be a continued focus in Europe on cybersecurity. Since NIS2, we have seen a new raft of legislation emerging. So obviously NIS2, we've got the Cybersecurity Act, the Cyber Resilience Act, and we also have DORA introducing operational resilience obligations for the financial sector. With this new legislation, we are also starting to see some key themes emerging across the cyber landscape. For example, the need for privacy by design and more robust notification requirements. And apologies, speaking of notification requirements, I have just realized I did skip over a little bit. If we could go back to just the slide with the slide 27 on mine. I just wanted to say, in terms of registration requirements and notification requirements, just touch on it briefly. Registration requirements: entities are deemed to be under the jurisdiction of the member state where they provide their services, but certain providers, such as cloud computing service providers and data center service providers, are deemed to be in the state where they have their main establishment, because they will be providing services across borders. And just because it's quite important, in terms of reporting obligations, it's much more streamlined than the NIS directive, which said without undue delay, effective companies will have 24 hours after first becoming aware of an incident to submit an initial report, a so-called early warning. Within 72 hours, you can add a bit more detail, and a final report should be submitted no later than 1 month after the incident. So sorry for choppy and changing there, but I just wanted to get that in. And yeah, I think I can now hand over to Hazel, who's going to talk about EDPB guidelines.
Thank you very much, Olivia. Thanks to my colleagues, we have a list of the EDPB guidelines that were produced this year. You'll be really pleased to know that I am not going to drone on about all of them in the next few minutes. I'm going to pick my favourites and say a few words about each of them. But you'll get the slides so you can read the summary and know which ones you have to read over your holiday period. So let's have the first slide, please. So here we have the output from the start of the year. Rights of access was quite a voluminous piece of guidance. For those of you who have worked in the UK, you probably wouldn't see a huge amount of interesting or new text here or guidelines. It read to me like something that the ICO might have produced, and the ICO has clearly produced advice on responding to DSARs for a number of years. Key points to note, let's say, first of all, that the controller isn't meant to assess the intention of the individual. You can't really, go and test them. What is their reason for a request? You have to deal with the request. And maybe the last point about the fact that you have to be very careful when you're requesting identity documents and verifying identity. It's got to be appropriate to the request that is being made. And you've also got to think about the service and how the person is communicating with you. So, for example, don't go asking for a passport if you don't need the passport. I'll mention briefly the dark patterns just because Leonie mentioned it. This was guidelines addressed to social media networks, but I think there's something for a lot of us here. There are a number of tips, or not tips maybe, pieces of commentary about how you should not be underhand, difficult, send data subjects or individuals off on a wild goose chase to find information or be able to use their individual rights. Worth reading for everybody, I think. Calculating administrative fines came out with a methodology, its guidance to supervisory authorities. It included some comments on, for example, how you might determine what an undertaking is, how you might set different fine levels depending on whether something is low level, medium, or high level. That's 0 to 10% of the maximum, 10 to 20%, and 20% and above. One significant point to note is in a number of examples, it was made clear that where the controller had ignored the advice of a DPO, that often made the example into a higher level fine because it was intentional. Let's move on to the next slide, please. Okay, I think there are a number of pieces of guidelines here and really not worth us spending a huge amount of time on. It's interesting that there is some guidance on how to implement amicable settlements directed towards supervisory authorities, but this is not something that is available in all EU member states. There's quite a significant number where the local legislation does not permit that. Let's move on to the final slide, please. Okay, so here we have some significant pieces of guidance. First of all, identifying a controller or processor's lead supervisory authority. You may recall that this has been around for a little while. It's now been updated to deal with joint controllers, essentially saying if there are joint controllers, you can't just select a joint lead supervisory authority. You have to look at each of the joint controllers and determine for each of them which is their main establishment and therefore their lead authority. So this could lead to some confusion or issues potentially as we see more and more joint controllership and potentially more and more joint controllership enforcement involving multiple supervisory authorities. Then the next point to note is personal data breach notification. Again, this is guidance that's been around for some time and has been updated. Somewhat negative, I would say, the update here, because it is making it very clear that if the controller is not established in the EU and nominates a representative, this does not trigger the one-stop shop, and therefore all supervisory authorities for the affected data subjects must be notified in the event of a breach. So it's no longer possible to say, actually, I've nominated a representative in, say, Ireland or the Netherlands, I shall just go and notify there. You must go through the process of working out where the affected data subjects are and do your notification there. Last point there is that we have an updated form for application for binding corporate rules for controllers, and we will be expecting a similar form for processors very shortly. So, unsurprisingly, my prediction from this is we're just going to see more guidance. We see quite a significant set of guidance coming from EDPB last year. The ICO has also not been lazy. It's been producing guidance, most recently on direct marketing in the last few days. So there's plenty for data protection advisors to be doing in 2023. Let's move on to the next slide, please. So we're now at the point where I can ask a few questions of my team, and whilst I'm doing that, I can just leave in front of you the fact that we have our YouTube channel and it is expanding and with new materials coming in all the time. So please do log on and view what's there. You will enjoy it, I am certain. So we have a few minutes. I'm going to try and ask questions and be nice to everybody. Let's start with Renzo. Renzo, what do you think? What do you think is going to happen to UK adequacy with all the legislation that you were proposing?
Well, interesting. I mean, I'm always an optimist, Hazel, as you know. I don't think the tinkering in the bill will remove adequacy at all. If GDPR fell off a cliff because of the retained law bill in 2023, then that would be a serious danger point. I think when clients ask about this, I always sort of make the point that even if we changed our law to not look like GDPR, there are lots of adequate countries out there who have not changed their law following GDPR. The early adequacy decisions are still in place. Some have changed, but Uruguay, for example, hasn't. Is anyone talking about Uruguay losing its adequacy? So I'm an optimist. We won't lose it.
Okay, you're an optimist. Okay, Leonie, let's pick on you. What are organisations doing following the IAB decision? Are they taking any active steps? Are they sitting and waiting? What do you see?
Well, what we're tending to see at the moment is a bit of a wait and see approach.
Oh, okay.
Because notwithstanding that, certain issues were raised by the Belgian decision, at the moment there is really no alternative equivalent framework that supports ad tech vendors and other ad tech intermediaries in quite the same way. So at the moment we're seeing that organizations are waiting. Some are mitigating risk to the extent that they can. So for example, I think we're increasingly likely to see consideration of different business models. So whether organizations might, for example, move towards contextual advertising rather than having such an emphasis on behavior targeted advertising. I think we're likely to see more direct deals between publishers and advertisers, for example, that rely on first-party IDs and perhaps are supported by a smaller number of vendors. So there's not quite the number of vendors in the ecosystem that's currently potentially the case. I think we'll see other risk mitigation, like perhaps narrowing the purposes for which personal data are being used to more basic TCF purposes. I think we're increasingly going to see, as I say, potentially move towards different models that rely on different technologies as well, potentially, in particular use of first-party ID. So a range of approaches, but I think primarily wait and see with some risk mitigation steps.
Okay, thank you very much. I see the clock has just ticked over to 5 p.m. UK, so we will need to finish there. So thank you all very much for your attention. Thank you for joining. Please join us on the YouTube channel. We'll send you the slides and the link. And just to say that the draft adequacy decision was published today, so maybe we'll include a link to that when we email out so that you can all read that as well. So as per Carlos's presentation. Thank you very much. Have a great holiday season and see you all in 2023.